Hello, everyone, and welcome to Topics and Decisions in Patent Law. I'm Joe Murphy.
I'm Reza Malagababa.
I'm Reza Sadr.
So we have a really interesting case today. As you saw in the thumbnail, we're going to be asking the question, is a drill bit an abstract idea? And the reason we ask that is based on a decision from the International Trade Commission, which is the body which oversees the importation of goods and can actually serve as a tribunal to adjudicate patent issues to prevent importation of potentially infringing goods. In this particular case, we have a complainant, U.S. Synthetic Corporation, who is the owner of several different patents and who brought a complaint to the ITC alleging violations of these patents under Section 337. And Reza Adams is going to actually give us a little background on the ITC in a bit more detail. And U.S. Synthetic Corporations asked the ITC to prevent importation of some allegedly infringing goods by the defendants or respondents. There's a lot of them, maybe 10 or more, initially named in the complaint. The technology here is directed to polycrystalline diamond compacts, so-called PDCs, which are compacts made of polycrystalline diamond and a substrate. And these PDCs can be shaped as cylindrical parts, as we can see in figure 11 of one of the asserted patents, the 565 patent. And these PDCs have found particular utility as super abrasive cutting elements in rotary drill bits. And the PDC cutting element typically includes a super abrasive diamond layer, the so-called polycrystalline diamond table, bonded to a substrate. And that's the larger cylindrical bit, and the PCD table is the smaller part at the top. The diamond table may be formed and bonded to the substrate using a high pressure, high temperature process, and you can make drilling tools such as cutting elements and drill bits, as we see here in figures 13 and 14. These are also from the 565 patent, where you can see the little cylindrical members around the drill bit are each individual polycrystalline diamond compacts. Of course, the complainant alleges that respondents infringed the asserted patents, so we can look at a representative claim from the 565 patent, and we'll look at just claim one. Now, I've included some highlighting here on this claim. It's obviously a long claim, so I'm just going to point out some of the relevant parts. And so we have kind of the functional characteristics highlighted in blue. That's the sort of the structural elements. And then we have the functional elements also highlighted. So we see on the claim, we've got diamond grains of a certain size, 50 micrometers or less. We've got a catalyst which also has to occupy at least a portion of an interstitial region. So these are, and we've got diamond to diamond bonding. So we have certain structural characteristics, and corresponding to that, we also have some functional characteristics. So we know that the polycrystalline diamond table has a coercivity of about 150 or more. The unleashed portion has an electrical conductivity less than about 1,200 Siemens per meter, and the polycrystalline diamond table exhibits a G ratio of about 4 × 10⁶. Now, G ratio is actually a ratio between where the cutting bit takes versus how much cutting it does through the substrate. And we've also got a substrate bonded to a polycrystalline diamond table. So we've got both structural elements, functional elements together in the claim. So I'm going to throw this over to Reza M, and maybe Reza, you can tell us a little bit about the ITC.
Yes, thanks, Joe. ITC, or International Trade Commission, is a U.S. agency that investigates the impact of imports on U.S. industry. Among its other duties, it adjudicates complaints by U.S. companies that can be qualified as U.S. industry, adjudicates complaints by such companies against importers for infringing their patents. And typically, when the complaint is filed, the commission determines whether an investigation should be initiated, and the case is basically then referred to an administrative law judge, ALGA, that then basically comes up with an initial determination. And the initial determination then can be finalized by the commission. The decisions of the ITC can be appealed to the Federal Circuit, which is, of course, the case in this particular case that we are discussing. ITC can issue so-called exclusion orders to stop importation of infringing products. There are limited exclusion orders that apply to a particular companies and stop importation of infringing products from those companies. Very rarely, also, general exclusion orders may be issued where importation of the infringing products are stopped regardless of which company they're coming from. Those are rarely granted because they have such a broad scope, but they do get issued, probably 2 or 3 a year, my understanding is. And they can, of course, the general exclusion orders can be very, very powerful. So that's really a little bit about ITC, where this case originated from. In terms of the posture of the case, as Joe mentioned, the issue on appeal here is really the issue of patent eligibility of the claims in this patent, and the claim is the one, the independent claim is the one that Joe referred to. So I turn it over to the other Reza on the call to discuss the issue of patent eligibility in general and how it applies to this particular case. Reza?
Thank you, Reza. So in this case, the Commission applied the framework set up by Alice Mayo, its predecessors, and some of later cases, but essentially applied that framework for subject matter eligibility analysis, where here in this next slide, we are showing the flowchart that summarizes that. Of course, this is borrowed from the USPTO's guidelines, and it's USPTO's version of it. So the steps come from that guideline. However, it embeds the Alice Mayo analysis as seen. It has 2 steps. In a step, and very familiar, always used in these cases. The step 1 of Alice Mayo essentially asks whether the claim is directed to a law of nature, natural phenomenon, or product of nature, essentially those judicial exceptions, and also includes abstract idea. These are the categories of judicial exceptions. And then if the answer is no, then the claim passes the test and goes on to other parts of the law to be examined. However, if the answer is yes, then the claim goes to step 2 of the analysis, which asks, does the claim recite additional elements that amount to significantly more than the judicial exception? Again, here, if the answer is yes, then the claim qualifies and passes the test. Otherwise, if the answer is no, it fails the test and it's deemed to be ineligible. So in this case, the commissioner, of course, the lower opinion also called the initial determination, both applied this framework. If you go to the next slide, in this case, they applied it to the claims at issue, those that Joe described. And under step 1, they decided the answer is that it is directed to a judicial exception, in this case, an abstract idea. And the wording they use is interesting. By the way, these we are going to later critique in our discussion part, but here we're just stating what the commission said. And then what the commission essentially said is that it's the claims are directed to an abstract idea. And the way they characterize the abstract idea is quoted here. They said that it's directed to the abstract idea of a PDC. Here's the composition. PDC that achieves the claim performance measure, whatever it is, G ratio or thermal stability, and has certain measurable side effects. At the end of the analysis for Alice step 1, also they have the following quoting. In sum, the commission finds the asserted claims are directed to the abstract idea of stronger PDCs that achieve the claimed performance measures and desired magnetic and electrical results, no matter how implemented. That's the way they have characterized and stated the abstract idea. Then they went on to step 2, and for step 2, they essentially said there's nothing more significant. There's nothing significantly more in the claims. they say they recite just result-oriented language and the recited physical elements are conventional. Thus, the claims do not include some additional features or inventive concepts, showing that it is more than a drafting effort to designed to monopolize the abstract idea. Here, they, of course, are quoting Supreme Court decisions. And essentially what they said here, both in two steps, is that if the claim had more meat to it, it had more specifics about what how they achieve the results, maybe structural limitations, they would pass even a step 1 or a step 2, but they do not have that. In its analysis, the lower court or the ID initial decision also mentioned that the claim has elements that they have no problem. Those are the elements that Joe mentioned with the composition, what's inside it, and then the elements that are problematic, and those are the qualifications in terms of the measurements, physical measurements, and they analyzed them separately and decided that those problematic elements actually cause the claim to be directed to abstract ideas. This is what essentially they decided. So the ITC decision, as the slide says, cover a set of goals for the PDCs that are a specification that the specification posit may be derived from enhanced diamond-to-diamond bonding, but they do not recite the way of achieving them. Those are the details they were looking for. They're exhibiting claim properties no matter what pressure was used to make them or how much catalyst is present in the PDC. They mentioned that the specification does explain ways to achieve those results, but they're not in the claim. And thus, they very much mention that there is an effort to monopolize every potential structure or way of creating those PDCs that are stronger with those properties. In other words, they talk about preemption a lot, as we are going to discuss later. Okay, so now we go to the next part about dissent analysis, which I think, Joe, you're going to talk about.
The dissent looks at the claim language and basically states that in order to define the improved PDC, the asserted claims require certain properties for the PDC, which are set forth in numerical thresholds, as we looked at. The intrinsic evidence indicates that the properties reflect the structure of the PDC. They require, the PDC, satisfies sort of specific parameters used for measuring cutting performance, such as the G ratio and I guess the thermal stability, which lead to improved performance. And I thought it was interesting because dissent almost used a problem solution kind of analysis, right? It said the patents describe a problem solved by the inventors as providing an improved PDC, and the invention, meanwhile, is described in terms reflecting its structure, including its microstructure, as we had mentioned, the grain size and the diamond-to-diamond contact. And this microstructure is quantified by various measurements, as I mentioned, the grain size, the coercivity, and magnetic saturation. So according to the dissent, really just looking at the claims to observe that they are directed to measurable compositions of matter for which eligibility should be routine, as the dissent points out. And not only that, and we've mentioned this before in some of our other videos, the dissent points out that the specifications to further disclose the claimed magnetic and electrical properties reflect the microstructure of the PCD. So I think this is the part that I found most persuasive. Maybe we'll throw it open discussion. The dissent said many properties of the patent materials could be described, in a similar way, in a functional way, right? As is often the case, material science and chemistry, intrinsic properties like density, pH, conductivity, and melting point result from other design choices, such as the choice of chemical inputs, processing parameters, and threshold steps, and that a particular material property of the composition of matter results from other design choices does not render it abstract. So I think I'm sort of persuaded by the dissent in this particular case. I mean, not only do we have the specific structural elements in the claim, we have the specific functional elements which are claimed, but we also have a correlation between the structural elements and the functional elements as taught in the specification itself. I kind of not, I fail to see how that, any of this is abstract. I mean, you know, and I'll open it up, but that's sort of my bias going into this. I don't see this as being abstract.
Just wanted to mention, Joe, thank you. I just want to mention that an oral hearing was held in this case before the judges, CFC judges, and the judges actually asked a lot of probing questions of both sides that maybe we can discuss during the discussion. You know, Joe, I tend to agree with you, but one of the things that I think also came up, it's in the briefs, also came up during the oral hearing, is that for the Section 101 for the Alice Part 1, the question is, what is the advancement that the claim provides over art? And here they characterize that as these particular properties. And then the question, I guess, was, as you said, is there really a correlation between these properties and the structure that is explicitly recited in the claims? And that's where a lot of questions arose during the oral hearing as well, because in the specification, they talk about, for example, the mean free distance between the grains, diamond grains, which is not in the claims, for example. And one of the judges, in fact, asked, well, why there should be a very tight correlation between the properties and the structure for it to pass 101? Why can't just a kind of a looser correlation would be sufficient? Because clearly structure is recited, but the question, I guess, was whether the properties would flow directly from the recited structure in the claim. And that became a point of contention, I think, in the oral hearing as well.
I think one way we can approach this type of rulings and similar ones that sound very problematic is that here the 101 analysis seems to encompass other sections of the law, like 102, 103, or even 112. In 2017, I co-authored an article in Northeastern's Law Review, which the title said that it says the fractality of the patent eligibility law these days after post Alice Mayo. And by fractality, we're using the metaphor that you have a phenomenon where you take a piece of it, magnify it, you see all the other parts of the phenomenon embedded in that. Here, when they talk about things like enablement, which is there in the argument, they talk about things like that, preemption, novelty, what you just mentioned, Reza, that let's find what is the advancement in the technology, and even they mentioned the word, where's the inventive section? And then let's focus on that. These are all, and 103 even, non-obviousness. These are all other sections of the law, which throughout the evolvement of the patent law, they have developed a very rigorous structure for approaching them, a very rigorous analysis that you need to follow. And when all that is thrown out and instead the judge or the examiner has this tool of 101 abstract idea, for example, to implicitly do all those, make all those judgments by themselves without using that rigorous structure, that's a problem. So a lot of these arguments may seem right in rejecting the claim, but I think always the question is, why is this a 101 issue? Why isn't it an issue of 112, for example, enablement, preemption, or novelty? That's one way we can look at these cases in these type of rulings.
The thing that jumps out to me is, so if you had claimed one of these polycrystalline diamond compacts and tables and not had the functional language, would it then have met the requirements under 101? So how does merely adding on a layer of, okay, it's got to have this coercivity and magnetic, functions and characteristics, how does that make it abstract? How does adding additional elements to the claim turn a concrete reified drill bit into an abstract idea. I just don't see it. I mean, and to your point, Reza, if you want to reject that and you say, if you want to say the specification doesn't teach one a skill in the art how to make and use that that polycrystalline diamond table, we have a code section for that. It's 35 USC 112. Why not just reject it under that? Why all of a sudden say, okay, yeah, you're claiming this object which can be used in a drill bit. We think you're claiming something that you didn't teach us, teach one a skill in the art how to make and use. So now it's not a patentable, now it's an abstract idea? That doesn't follow. I mean, I don't see it. I just think it should be under one. If you want to make that argument, make it a 112 rejection.
May I play devil's advocate to what you
please.
asked? Because I want to say something that I know Reza then have an answer for my devil's advocation. Here's the answer to, so you asked the question, if you start with just a composition of matter, a claim such as that, without the extra recitations, this claim should obviously pass 101 muster and go to other sections. Why now adding more limitations suddenly brings it back to 101 rejection? Very good question. I always had that, even under the old law. I mean, the old cases, even starting from Alice, the court clearly says that the mere changing the claim from like a method claim, which is like a software algorithm, to a computer claim, which is a system claim, shouldn't let the patentee get away by hiding it under a computer. So they said, true, computer is a system, it's a device, but that's just embedding your abstract idea under the guise of a computer, and they said reject it. And this court, this commission also once did mention that, did cite that argument and said we are doing the same here. And I think, Reza, you had a good answer to I think it's a good answer to my reasoning.
Yeah, I mean, I think what Joe says makes a lot of sense to me as well. But I think the idea that this is similar to an algorithm running on a computer, it to me doesn't quite hold water, because in that case, the algorithm is not a result of the structure of the computer. It's separable from the structure of the computer. Here, the properties of the composition flow from the structure of, they're not separable in that sense. So that analogy doesn't quite work. But one of the things that came up during the oral hearing was, where is the line? Is it always the case that any composition of matter would be patent eligible? Or are there certain claims to composition of matter that would not be patent eligible? For example, one of the judges came up with this hypothetical claim, a composition for treating dementia. So in that case, one could argue that there's clearly no structure here whatsoever. Therefore, it's just the result-oriented sort of claim, and therefore it shouldn't be patent eligible. But even then, in that case, it seems to me what Joe was saying makes more sense to me than treating it under 101, because in that case, the scope is so broad that you haven't really enabled the full scope of all compositions that could be used for treating dementia. So even in that case, you can deal with it in my view, much better using other provisions of the statute rather than 101.
Right.
So we are back to the fractality of 101.
Yeah.
Embedding other things.
And also, one of the issues is this correlation between the properties and structure. It is true that in the specification, there is more about the structure than it is in the claim, such as the mean distance between the grains. But I don't think you can ever be completely sure that you have recited all the structural features that result in the claimed properties, because there could be, polycrystal, the degree of polycrystal nature of these grains that could be also part of the reason that they provide these properties. So it's a little bit, I think, it's too high a burden to put on patent applicant that you need to provide every single structural feature such that the properties would naturally flow from those features.
Right. What about the preemption concerns that are raised. And I think the Morse case, which again we had discussed previously, it was actually mentioned in the decision we're looking at. And it's I'm going to set, so I set preemption up so we can address that, but I'm going to knock it down now with the dissent again, which I found to be very persuasive, because the dissent's example as to why preemption wasn't an issue for this case actually was that one of the defendants later on actually developed a non-infringing version of one of these polycrystalline diamond tables. So they weren't preempted by this claim set from making something, similar enough, but still was not infringing. So, what I know, there's the quid pro quo in patent is, of course, you get your limited monopoly for a certain number of years for the enabling disclosure. What has the public given up here if one can make a non-infringing version of this? They haven't been blocked out from anything. Preemption is a limited concern to me.
Well, I agree with you, but one thing that sort of comes up is that if again, I think in my view, it goes to the scope of enablement and the scope of written description. For example, the Amgen case that we had a video on, I mean, it speaks to that in a different context. But the question, I guess, in my mind is that if you could have a totally different composition that nonetheless has the structures recited in the claim, meaning that the structures recited are so broad and so generic that would cover all kinds of different compositions that would have those properties, then one could potentially say that you haven't enabled the full scope of the claim because you haven't provided enough different types of compositional structures that would have those properties. Again, it seems to me that's better dealt with under the enablement or written description, the 101 prong of the statute.
Right.
Yeah. Actually, I think both in the opinion and also in the oral argument, this comes up, that there are products, apparently they were even discussed during the oral arguments, that, in the ITC arguments, that products that are made under different manufacturing conditions, different pressures than what the specification explains, but had the same properties. And then again, I think they were used as an example of preemption, claiming more than what you deserve, but doesn't belong under 101. I agree with you. Reza, you mentioned the oral arguments, which happened 2 days ago on 8th, I believe, October 8th, 2024. And I'm very curious to see what the ruling will be, because contrary to what I thought, that it's slam dunk as soon as we have a composition of matter, why to even bring it under 101 abstract idea? Judges didn't seem to focus on that. Even they kept asking for that borderline that you mentioned, that does every composition of matter, can it never be rejected under abstract idea? And of course, the attorneys dodged that question, never explicitly said no, apparently because they have something in mind that this could happen. So I'm interested to see, because up to now, as far as I know, the jurisdiction under 101 has never addressed this type of claim as being abstract. It could have other problems. So it's going to be an interesting ruling.
I think it's going to be a very interesting ruling, and it was very telling for me that towards the end of the oral argument, one of the judges asked, I don't know whether it's 101, 102, but isn't it the case just that the patentee is claiming more than what they invented? This sort of uneasiness with the breadth and the fact that the structural features perhaps are too generic. So definitely, but then again, there are other provisions of the statute that can deal with that issue rather than 101, which should really be a which is really the gating question, and that shouldn't be such a huge burden to overcome to get to the other part of the patentability analysis.
Yeah, I'm glad that once in a while, a couple of judges, maybe it was Judge Chen, that repeatedly mentioned, isn't this a 102 question? And he mentioned a couple of times, isn't
Yeah.
this an anticipation question or of that? So even I think enablement he mentioned. But again,
And actually, the interesting part of this is that apparently they were not deemed to be obvious, the claims. They passed the obviousness hurdle. So
sure, they
if
did.
it's inventive, then why can't you just
Right.
rely on that and say, you know, that passes 101? But it's, again, as you said, Reza, is a lot of sort of conflation of these different provisions of the statute.
Again, in my opinion, here we see another case that it's a smell test, first of all. They see a claim, like you said, they're uneasy about it. They know this claim should somehow be it's not good, right, so it should be rejected. But where to put the analysis, I think they misjudge it and put it under 101, which has become this kind of, we say, even dangerous tool or dangerous weapon in the hands of a judge or an examiner to just reject any claim without the rigorous analysis that is required in other sections.
Yeah, and in fact, I mean, they do mention, they refer to the Supreme Court case that said basically there's a danger that 101 could swallow the entire patent law if it's not applied correctly.
Well, that's a great discussion, and I think maybe we'll wrap it up there. And thanks so much.
Thank
Have a
you.
great day.
You too.
Bye.